I would like to introduce our next speaker, Negar Azmudeh, who's the Assistant Deputy Chairperson with the Refugee Protection Division in the Western Region of Canada at the Immigration and Refugee Board of Canada. And Negar Azmudeh was a practicing lawyer before she was appointed as a member of the Refugee Protection Division, or the RPD, in 2008. Since then, Negar has held various positions at the Immigration and Refugee Board, including as a member of the RPD and the Immigration Division, a legal advisor, and a coordinating member. She is currently acting as the Assistant Deputy Chairperson in Western Canada. So I'll let you share your screen now, and then you can take it away. Thank you, Negar.
Good morning, everyone. Good afternoon, Azadeh. Just allow me to share my screen. And just a second. And if I can't, because I'm clumsy, do you see my screen?
Yes, it's working.
The PowerPoint?
Yes.
So just to clarify, I am only the acting Assistant Deputy Chairperson, and I'm very pleased to be here. Thank you very much to you, Bahar, and to the Refugee Hub for inviting the RPD to today's webinar. We basically know that it's been very challenging for all of us with the unprecedented changes that we experienced with COVID-19 in ways that we never thought we would anticipate. And I acknowledge the difficulties and the uncertainty that everyone is facing, but particularly the more vulnerable groups, including the refugee claimants who've been waiting anxiously for hearings with the RPD. We are very grateful to the stakeholder communities, councils, settlement agencies, refugee support groups, each and every single one of you for working tirelessly to provide services during the pandemic to a group who really needs it. My presentation, I think, will last around 20 minutes, and I will answer to all your questions afterwards. And I trust that you know how to use the chat, raising your hands, and I'll make sure that I will hopefully answer all your questions before the end of the webinar today. Sorry, just give me 1 second because I am trying to get to the, okay. So basically, just to get into the nuts and bolts of what has been happening in the world of the RPD, once the pandemic hit in March, in a nutshell, we all left the office on a certain Friday afternoon. I believe it was around March 13th. We knew that the restrictions were increasing because the numbers were increasing, and we were told to take our computers, but we really never anticipated that the magnitude of the change to be as big as what we ultimately experienced. And due to the pandemic in mid-March, the RPD had no choice but to cancel all in-person hearings. And this was to protect the health and well-being of the staff and those who appeared before the RPD. At that time, the RPD also issued a practice notice on the temporary extension of time limits for filing of the basis of claim forms, or the BOC. This practice notice was later updated in late August and extended the deadline, or the time limit of filing a BOC from the normal 15 days to a 45-day time limit. So it's an increase of 30 days. And then on June 23rd, the RPD's Deputy Chairperson issued a practice notice that was called Practice Notice on the Resumption of In-Person Hearings, and provided information concerning the resumption of the in-person. And in person, really, it could also include a video component, but it really means that the parties attend the hearing at our offices. And initially, it created some controversy because the in-person hearings, we wanted to maximize social distancing the best we could. So initially, a decision was made that the interpreter would attend by telephone to avoid yet another person to be present. And that's also because we were and we continue to be limited to the number of people we can have at any one time in our building. And that's due to public health concerns. So at any one time, our building capacity has been reduced to 30% of what it was. So in this context, the decision was made that the interpreter would be one less body if they can appear on the phone. And because we had a limited number of people who could come, we could afford to give 2 hearing rooms to each one hearing. And then we would put the member in one room and then the parties in another. We thought that this would facilitate the counsel and the claimants to be able to share documents if they wanted and to have some proximity. But this was while safety measures were taken into account. Plexiglass was put into every hearing room. Circles were drawn on carpets to make sure that people would stick to the area that they were designated to attend. The airflow had changed to include a lot more outside air into the airflow system, and high quality filters were also put into place. And it was in that context that the initial phase of the in-person was provided. And at that time, the practice notice also provided some flexibility to apply the rules. It offered some flexibility on how to submit documents to the RPD. E-post was encouraged. For the first time, email addresses were created to allow the parties to file their documents by way of email. And certain rules and the requirements were relaxed on, for example, the requirements of making formal applications, to provide formal documents to support those applications, or to provide certain supporting documents, such as medical notes in the event that people needed a postponement. Also, the practice notice stated clearly that the RPD would apply its rules flexibly, and where the parties have difficulty complying with them due to COVID-19 pandemic. And that included on even, for example, providing corroborative documents to support the substantive elements of the claim. Sometimes people would have difficulties with obtaining those corroborative documents because in the home countries, the offices were closed, documents could not be obtained, and so on and so forth. And the members were basically briefed on the practice notice and the requirement to offer a contextual and flexible interpretation to the rule. And basically, other measures were taken. For example, the old directive of exempting children under 12 to attend the hearing was extended to children under 18, while understanding that this may not be possible for some families who do not have access to childcare. So basically, people who could not leave their children home were not being punished in any way, but some flexibility was offered to those who wanted it. So I encourage you to go and read the practice notice, because we have since changed our in-person hearings, and I'll get to that in the sense that now, in response to some of the objections by the stakeholder communities and their concerns for a breach of natural justice by not having the interpreter present, by not having the parties present and all of that. Now the in-person hearings take place in one hearing room with the interpreter also present, but we have also upped the safety measures to ensure that basically people are safe at all times. And that includes a cleaning regimen, that includes sanitization, protocols for how to use the washroom so that not too many people are there at any one given time. Again, the airflow system, the checking on those systems that have taken into place and all of those things, and making the wearing of masks at all times, including inside the hearing rooms, mandatory. So on August 26th, the IRB's chairperson, Mr. Wax, provided an update to the resumption of business resumption. And that included basically three measures. One was the changes to the in-person hearings, but most importantly, it also offered updates on the RPD's paper-based file review process, the RPD remote hearings, which is quite important, and I'll get into it, and the RPD in-person hearing. And let me go through them in detail. So some of you may be familiar with the FRP, or our file review process. In short, it's a paper-based process. And under the Act, we can only do a paper-based process when the result is ultimately going to be positive. And this is basically for manifestly founded claims. And usually they're well supported through written documents. So there is no reason to compel the parties to the hearing because on the face of it, everything appears to support a positive decision. There are certain legal restrictions. For example, if the minister wants to participate in like in a hearing, then we have to have a hearing because they have a right to question the claimant and make submissions. And if they want to raise credibility concerns, they're entitled to do it. So basically, as I said, in the August 26th update, the chairperson announced that the RPD has introduced a number of important changes to significantly increase the number of refugee claims that would be resolved without a hearing. The RPD basically increased the size of a task force that was created specifically for this purpose. It's called the Task Force on Less Complex Claims. And in the past, they used to be called the Inventory Reduction Task Force, but basically they were doubled in size, and they were mandated to basically use some of the adjudicative tools that we have, including case management conferences, to narrow the determinative issue to the extent possible, and to basically to allow counsel to also proactively request a claim to be decided by FRP if they can point to the documents that would support a positive reason. This was in the context of increasing access to justice for the cases that could be resolved fairly and efficiently without a need to compel the claimants to actually a physical hearing. And other measures basically was to proactively solicit well-founded legal arguments, well-documented files with evidence that could basically support a positive decision. Another initiative that the RPD took to increase access to justice was basically the setup of the remote hearings. The remote hearings is not the traditional video conferencing that we've been doing since the early 2000s in the board. It's basically the type of refugee hearing when nobody is potentially on the IRB's premises. And we started in the summer and during the shutdown on a very small scale pilot project. It started in early July, and it started mainly in the Western region, and that was because our registry was already capable of supporting us remotely, and a small team in Toronto. MS Teams which is a software quite similar to Zoom that we're using now, and it has capabilities including raising your hand if you have a question, sharing your screen, and so on. And MS Teams was used as a platform and it was basically migrated to the IRB's secured network so that the MS team would run a secured hearing. Basically, all the IRB staff are required to attend the hearing using their IRB provided equipment and the VPN that puts them directly on the IRB's secured network, and that's how they attend the hearing. However, the claimant counsel, the interpreters, they have to use a private device that the private device needs to be secured according to basically the cyber safe standards of the Canadian government, and like we provide the information to the parties, and it offers information on an antivirus and like how they're supposed to get their devices to the point that they cannot be breached easily by a third party. And ultimately, we basically, knowing that this would depend on a lot of external resources and factors that not every claimant may have, including access to a private setting, access to high-speed internet, access to a device that can support a connection that is reliable, access to a relatively and a reasonably safe device, and all of that. So basically, because of all of these potential limitations, this program is entirely consensual, and it will not proceed if the claimant or counsel do not want to proceed. And basically, the consent is provided in advance of the hearing, and it's confirmed at the hearing as well. So the small scale pilot project started in July, and it continued until September, when we basically did another stakeholder outreach. By then, those who had been, who had participated in the remote hearings, they actually liked it quite a bit, and we got the mandate to expand it. And right now, we are basically giving the choice to all claimants and counsels to have their hearing scheduled remotely if they wish. We still have certain limits on the type of cases. Like, for example, we anticipate the minister to be able to participate in remote hearings sometimes in December or January. Like, this is not a suitable platform, for example, for the claimants who are also detained. So there are some limitations, but the majority of the vast majority of the cases can have can have the hearings held remotely if the claimants and counsel would wish. And at this time, we are also not doing it for claimants who are not represented by counsel. So the transition to remote hearing was a very significant undertaking for the RPD, because obviously the suitable platform had to be identified. MS Teams was identified in part because of its end-to-end encryption and the fact that it allows all the data to be recorded on a server in Canada that it's in IRB's control, so IRB's own basically servers. And basically it was launched quite successfully. And as of September 30th, approximately 100 remote hearings have been conducted in the Western region alone, and 50 of them were in Vancouver, 30 in Calgary, 14 in Edmonton, and 7 in Winnipeg. And at the end of each hearing, claimants and counsels were provided with a survey, and there were questions on both the technical aspects and the procedural fairness issues. And basically, because those were some of the initial concerns that the stakeholders had, and we wanted to ensure that we had successfully addressed what was raised. And the RPD has now trained all its members and has increased its capacity to the point that, as I said, the claimants have a choice to proceed remotely if they want to. So moving forward. I went through the RPD in-person hearing a little bit, but I'll expand on it. As I said, the chair's August 26th update announced that by mid-September, the IRB would begin its transition to full in-person hearings, where all the parties, including the interpreters, are in the same hearing room. And in doing so, the IRB was very vigilant to follow all the guidance from the Public Health Agency of Canada, which specifically reviewed the IRB's health and safety protocol and concluded that they offer robust measures to mitigate the risk of COVID-19 transmission and infection. And the extensive health and safety measures in place basically were communicated to all parties as part of the changes we made to the notice to appear package. And they were also provided on IRB's website. And these include that inside the hearing rooms, physical distancing measures are fully in place. The use of plexiglass was increased to be barriers, and non-medical masks they became mandatory and they must be worn in the hearing rooms, including when testifying or providing submissions, subject to some exemptions that are listed on IRB's health and safety webpage. And like, for example, if momentarily the member needs to request their removal very shortly for the purposes of identification. And individuals who wish to be exempt should raise their request with the presiding member. And given these new measures, we have tested our audio devices to make sure that the voices are not muffled, and we reconfigured them to allow for better recording while the parties are wearing masks. And hearing rooms, we have protocols that includes the sanitation of the hearing rooms after each hearing is done, as well as public spaces, including bathrooms that are sanitized at least twice a day. And there are sanitizers on every desk. The participants are asked to sanitize their hands while entering the IRB facilities. They have to answer certain healthy questionnaires. And as of tomorrow, all the staff are also subject to answering those questionnaires, at least in BC, in response to some of the more recent measures that our public health is asking us to do. So in addition to self-assessment and all of that, most of the information is provided in the notice to appear. And the percentage of the external airflow that in the ventilation exists has increased in all IRB facilities, and our previous filters were replaced with high quality filters. And the extra attention is being given to ensuring that the ventilation maintenance, the scheduled ventilation maintenance are adhered to promptly. And the IRB is also carefully monitoring the flow of traffic. This may result in people receiving notices of appears that are a bit scattered in times, and that's because we cannot have too many people on our premises at any given time. And the breaks have to be staggered as well, because again, accessing the hallways, or now there's a protocol for it, accessing the public spaces, including washrooms and all of those things, to make sure that in limited number of people can access them while maintaining physical distancing. And if there is a confirmed case of COVID-19 and is brought to the board's attention, basically we follow all the public health protocols and notify the people that the public health officials ask us to notify. And as we move forward with the in-person hearings and remote hearings, the board will stay on top of the public health requirements and will adjust our protocols as required. And we learn from the experience, and we really appreciate your feedback because we take them very seriously, and we basically move forward in the context of the reality that we'll have to live in at any given time. Another exciting news that I can share, and it may address one of the questions that was also earlier raised, was the creation of the gender-related task force that basically also, it was launched in the summer of 2020, and it was in response to the stakeholders' concerns with some of the IRBs, the lack of proper application of, for example, the gender guidelines in the past, and certain shortcomings that we responded to by the launch of the gender-related task force. And basically, there are a group of highly experienced members, 21 of them from across the country, that basically they had to compete to sit on the gender-related task force. They were basically vetted and chosen and fully trained with 5 weeks of training. And these were already fully trained members who were subjected to another 5 weeks of training on trauma-informed adjudication and to basically to refine best practices of adjudication, such as on how to focus on the determinative issue, how to approach a certain topic only if resolving it has anything to do with resolving the ultimate result of the case, and so on and so forth. And I was actually quite thrilled at the caliber of some of our trainers, because they were really subject matter experts in the field. And one of, I mean, I can't really call it an advantage, but one of the byproducts of the pandemic was that we could really draw on the talents of multiple experts from across the country, because travel was no longer an issue. The entire training took place over Microsoft Teams, and all the members from Montreal to Ottawa to Vancouver and elsewhere, they basically participated on MS Teams, and the experts joined in when they were scheduled to attend. Some of them include, for example, Dr. Hilary Evans Cameron, who's written an entire book on credibility in the context of credibility assessment in the context of refugee determination. Dr. Chantal Tai, who basically is a practicing lawyer and a professor, and her expertise is on trauma-informed adjudication. We combined some of these theories with some of the practical aspects of how to deal with real life situations inside the hearing room, when the member also has to balance several factors and react quickly to an unforeseen situation. And basically, we are hoping that some of the best practices that the gender-related task force will basically will also put in place can be taught to the entire RPD member cadre in due course. So basically, the focus was on how to get all the relevant information without re-traumatizing the claimants, and basically understanding all the precautions that a member has to take through a gendered lens, and understanding how intersectionality and harms are related. Basically, they created a lot of sort of training opportunities and practicing opportunities for the members to ensure that, I mean, it is our goal for every refugee claimant to get a fair and efficient hearing, but people who've gone through a lot of trauma, they don't need to be re-traumatized in order to, and they don't need to be overly stressed from the fear of having to go through certain experiences of their lives when they're in a respectful environment where their questions when they're questioned when needed. The member explains to them why certain topics need to be explored more or why they don't need to explore them. They are respectful and responsive to some of the triggering points that may make them a little bit upset. They will understand better on how to manage their hearing time and how to provide breaks at appropriate times and all of those things. And we are hoping that the initial training that was limited to the gender-related task force members will basically can expand to all members, because I think all hearing types can probably benefit from it. I also want to highlight that all RPD members across the country also they have received refresher training on the related SOGI guidelines in February. And the SOGI guidelines is basically for the sexual orientation and identity guidelines for that again, they require more trauma-informed, adjudicative knowledge and styles. And the overall aim of all of this is to ensure that all RPD members consistently display an awareness of the current understandings of the gender-related persecution in refugee law, are oriented to recognize and assess relevant grounds of gender-based persecution, including those that have not been expressly advanced, because again, being a woman affects every aspect of a woman's life, and sometimes they don't expressly think that pleading it is something that they need to do, but the members are trained to be mindful of those cases as well. And the members are mindful of the possibility of re-traumatizations of victims of gender-related persecution and are able to question witnesses in a trauma-informed context. So we are hoping that the members are well equipped to elicit and consider relevant evidence in a respectful and sensitive manner, appropriate to the context of the hearing, and they're mindful of impediments to witness testimony in gender-based claims, and that they are prepared to apply appropriate procedural accommodations to make sure that basically they can aid with witness testimony. And I also want to inform you that the guideline, like the gender guideline, guideline 4 on women refugee claimants fearing gender-related persecution, as you may know, it was launched in 1993 by then the chairperson Noor Jahan Mawani. It was a revolutionary document that basically put gender-based persecution on the map. And basically a lot of other countries followed Canada's lead subsequent to the gender guidelines being launched. However, right now, the IRB is basically consulting with stakeholders for an update. And basically, the present comprehensive update of Guideline 4 will renew the board's commitment to ensuring respectful and consistent determination of gender-related refugee claims. So basically, more operational things and more sort of nuts and bolts. Actually, I'm quite pleased to tell you that the Western region of the RPD has never been as large as it's been now. We currently have 31 members in the Western region, and we have 2 offices, one in Calgary and one in Vancouver. We have basically 6 members in the Western region that belong to the GRTF, or the Gender-Related Task Force. And generally, of the 31 members, we have 22 of them in Vancouver and 9 in Calgary. You're probably interested to know what our inventory looks like, and I'm only focusing on the Western region's inventory. And these are basically numbers as of September 30th. And basically, we have 5,400 cases in front of us, and that includes principal and associated claimants, 5,426 to be precise. And principal claimants only is 3,179 of like in the Western region, which includes all Canadian provinces west of Manitoba, like Manitoba, Saskatchewan, Alberta, BC, and the two territories, Northwest Territories and the Yukon. And within the region, Iran is the #1 source country, followed by India, Nigeria, Mexico, and Pakistan. However, across the different places where we do hearings, or at least we have claimants appearing before us at the hearings, the country makeup is a bit different. Like, for example, in Vancouver, the high source countries are Iran, India, Mexico, and Nigeria. And in Winnipeg, there are Nigeria, Eritrea, Somalia, and Bangladesh. In Calgary, there are Pakistan, Mexico, Venezuela, and Nigeria. So I think depending on which city you're in, there is a more established community, and there may be more claimants of the same country of origin in one place, but these were basically the general numbers that I went through. So as Azadeh said, and as you may expect, our referrals have been far lower than average due to the impact of the pandemic. And that's because there have been reduced international travel and border closures. And the referrals for the 6 months of April to September have been about 30 refugee claimants per month, which is far less than the hundreds that we saw every month in the past. So also, this is in part due to the limited incapacity of having eligibility interviews at IRCC, which only partly resumed on September 21st. And as Azadeh said, at very low numbers per day. So we expect the backlog of refugee claimants awaiting eligibility interviews to slowly trickle down to the IRB as well. So basically, like in a month like August, we had, in June, we had as few as 17 referrals, and since the pandemic started. And in April, when it was still new, we had 49, which was the largest. And then in the rest of the months, the numbers have been hovering around 30. So you probably want to also know more about our finalizations. So the pandemic that forced us into office closure basically had a significant impact on the output, because the members had no hearings, but they had time to catch up on their reserve decisions. And basically, they wrote the decisions. And they basically, for the 6 months period of April 1st to September 30th, Western Region finalizations on merits were about 1,100 total claims, which is like 650 principal claimants, because some claimants, they include the family. So it's one decision affecting more than one person. So we expect that with the processes and the measures that we've put into place, that hopefully we can have a significant increase in the finalizations in the months to come as well. So basically, this was the RPD since the beginning of the pandemic in a nutshell. And I appreciate your time for listening, and I'm looking forward to hearing your questions. So let me just sorry, let me just
Thank you.
unshare my screen if I can.
Okay.
Okay.
Great. And
Sorry, I'm just trying to You still have my screen?
yes, but let me. There we go. I think I unshared it for you. Did that
Perfect, thank you.
work? Yeah. um,
And I have a black screen in front of me, so I don't know if you see me, but I count on you telling me what the question is.
there we go.
Oh, I
Here
see.
I am.
Okay.
Okay, I'm gonna try to. Oh wait, I don't.
Oh, sorry, and my video, I think I have to restart. Okay, perfect.
For some reason, there's a black screen.
I think it's probably my fault. I apologize. I don't like it's probably like. Let me see. I press share to unshare, and it doesn't let me.
Okay.
Oh, I see your.
There we go.
Yeah.
Okay, so while it's up, I'll just let everyone know I'll be posting, because I've been getting this question a few times. I'll be posting the video, PowerPoint, and the resources on the training section of the BC Refugee Hub. And I'll start with the first question we have. Okay, could you please clarify if the GRTF will serve as point adjudicators for gender-related claims? Is the expertise gained by the 21 members in this training period going to be expanded across all adjudicators?
Well, the GRTF was really established in the summer, and we are hoping that that would be the case. However, I can't really speak to it because it's in its infancy. And like everything else, we have to monitor its progress. There are basically metrics. We want to do a quality control. We are expecting to see a marked improvement in the quality of decision making, which doesn't include it's not limited to the final set of reasons. It very much depends on the claimant's experience, whether they experienced a respectful hearing, whether they feel that they were heard. All of those are things that we would like to basically measure, and hopefully we expect to get positive results. And if so, I believe that the lessons learned will have to be shared with the rest of the team, because I think a lot of what can be learned is not limited to just gender-based persecution. Did I answer your question? I hope I did. If not, feel free to let me know.
Okay, great, thank you. And then there's a follow-up question sort of on the same topic. Can claims that have already started being heard by a board member, already one hearing has taken place, still be referred to the Gender Task Force in cases where the claim is gender-based? Is this done automatically by the RPD, or should claimants or the council submit a request?
Well, if the claimants have had, let's say, their hearing started because, for example, they had one session and for whatever reason there is a resumption set, the member is seized. So they will continue to adjudicate and decide on the claim. However, the RPD on its own initiative, basically we went through our entire inventory and we reassigned cases when we realized that there was a gender case. To the GRTF. So, and this could result in postponements because like we want all gendered cases to be heard by a GRTF member. And with the upcoming cases, if there is a gender related matter that it's not pleaded or argued, then I can't really speak to it because not every woman in the world has necessarily a gender-based persecution type of claim. But if there's anything to support the finding that the persecution is related to the gender, it goes to the GRTF.
Okay. Okay, so the next question, are there some asylum seekers post who had a postponed hearing date by our IRB? Sorry, there are some asylum seekers who had a postponed hearing date by IRB in March and June, like in that time period. Do they have priority to get a scheduled hearing soon? Do you know anything about the scheduling or?
And well, actually, yes, I do. There were unfortunately lots of people who had their hearings postponed, and in scheduling, in putting cases on the schedule, we have to look at a number of factors. One is exactly what you said, whether or not they were one of the people who had lost a hearing date, and it's one of the priorities. And there are other priorities as well. For example, if there are detainees, unaccompanied minors, and I can't really speak to whether or not in every single scenario they will trump someone else, but it's definitely a factor that it's a very significant factor in putting cases on the schedule.
Great. Okay, this is a bit more specific. So on April 7th, 2019, there was an ordinance for asylum seekers who applied in the US, the UK, Australia, and New Zealand that they will not be eligible to seek asylum in Canada through IRB, and they have to go through a pre-removal risk assessment. The person is wondering if this ordinance is still active.
Yes, it's basically part of the changes that the government made to the regulations that have to do with eligibility. I'm not sure if it was the act or the regulations, but anyways, it's legislative. And if they're found not to be eligible, the IRB has no jurisdiction over the claim because the claim should not be referred to us. So yes, it continues to exist.
And the asylum seekers who are rejected from the US, are they eligible to apply for humanitarian and compassionate under that category in Canada right away instead of applying for a PRRA?
I can't speak to it because I don't know. I don't know if Azadeh knows anymore.
I can answer that one. So yeah, this process, it's a bit different than so there's the old PRA, or the PRA that people had before this legislation came into place, and that would be something where after they got rejected in Canada, they would have access to a pre-removal risk assessment before they got removed, and usually it was paper-based. This new one will have a hearing also attached to it, but with an IRCC person who's going to be determining whether they qualify for refugee status or not. And the hearings are usually held if they have any concerns. So they can't give a negative decision without a hearing. They could give a positive decision without a hearing, but they can't give a negative decision without a hearing. So IRCC will be putting in place hearings. They started that process right before the pandemic hit. They started scheduling hearings for these individuals directed to the new pre-removal risk assessment, but that got shut down because of the pandemic. So they're starting to see how they could restart that. Humanitarian and compassionate applications, you can't do one usually when you have a refugee claim in process with the IRB. And usually you have to either like continue with that and get a decision and then apply for humanitarian compassionate, or withdraw your claim and do that. Technically, under the legislation, they should qualify for a humanitarian and compassionate application because they are not before the IRB for the refugee claim, but they're before the PRA at IRCC. I haven't seen any cases yet of people doing both at the same time to see if IRCC will either process them both at the same time, or if they'll process one first and then look at the other one. But there was some questions within IRCC on whether they would expedite processing of both at the same time, just to ensure that they don't have duplication of decisions and work. So technically they can apply for humanitarian compassionate. Of course, those applications really do depend on your settlement and your establishment in Canada as well. So it really would depend on the legal advice you get from a lawyer of as to whether you have a good chance with a humanitarian and compassionate application. They do also cost money to submit one. So I really recommend that anybody who is thinking of doing that at the same time as a PRA process to discuss with their lawyer if it's something that's a good idea in their case or not, and get some legal advice before they decide to go ahead.
Okay, thank you.
By the way, I'm very pleased that an interpreter had also commented in the chat that they like the remote hearings.
Yeah.
Yeah.
Yeah, they said it's actually not that bad at all, and it's been okay. Yeah. Okay, I have another question. There are cases of claimants who had initially been told that they were not going to get a hearing, and then later that was changed and they were advised that they will get a hearing and that a government representative will be in attendance. Is this a COVID related, or do you have any insights on that? I guess the part that there is a government representative that will be in attendance.
I would suspect that they're referring to the Ministers' Council. And I tell you in a minute what that really means. Basically, if they were told that the case is being considered for FRP or file review process, like they're notified, the minister is notified, and if the minister decides to intervene in the claim, then the case has to be screened out of FRP and must be referred to a hearing, where the minister may participate in writing, and that means that they can submit arguments or evidence to support a challenge to the refugee claimant. And the member will have to consider that and weigh it against everything else that they have, and question the claimant if necessary on the topic or whatever else that they want to. So it means that the board must respect the minister's right to have to be present in the hearing room. But then I can't comment on whether or not, like, it depends on the merits of the case. It doesn't mean that in every case that the minister participates, it will result in a negative decision or a positive decision. It would really depend on the nature of the evidence in totality.
Okay, and then we have another question, and I guess it's more of maybe your opinion, but in your experience, are there differences in the hearing results between in-person and remote hearings? Have you seen any differences, or?
Not really. In fact, the hearings are supposed to be fair and efficient, regardless of whether they're in person or they are held remotely. If there are any concerns with the fairness of the hearing, the members are trained to react to it. In other words, if there are issues with the connection, if there are any issues whatsoever with the integrity of the process or whatever. So the idea is to ensure that there would be no difference.
Okay, and this is more of, I guess, for both of you. The question is, and I got this through email, this question, if there's an issue with the lawyer that someone is working with, and they weren't happy with the performance of the lawyer at the hearing, for example, or through the process, what are the steps that an individual or a claimant can take because of that?
Azadeh, I'll let you answer, but I only respond to the IRB related part of it. The IRB does not take the position that the lawyer is good or bad, unless the behavior or the performance or whatever, it's a marked departure to the point that then that there have been very few instances where the IRB has notified the regulatory body, but generally we don't participate in commenting on the quality of representation. However, if we have to deal with an argument that, like, for example, please reopen my case because the quality of my previous lawyer was so bad that I would not have gotten the negative decision that I got. Sometimes these arguments are made before the RAD, and I don't want to comment on how they deal with it. They're sometimes made in federal court as well. And basically, the RPD's rules since the reform in 2012, they try to mirror some of the federal court practices, that we will only consider it if that lawyer who is the subject of the complaint has been notified and has been given a fair opportunity to respond. And then if they have done all of that, that argument is taken into account in the context of the evidence and in the context of everything else. And sometimes it's very compelling and the reasons to allow the application. And sometimes the argument or the lack of diligence does not have anything to do with the way that the case was decided or the evidence that was brought out. So it depends on the, like it's a case by case sort of analysis, but we will consider it if they comply with the rules and they give a fair opportunity to the lawyer to respond. And beyond that, I leave it to us.
So I don't have too much more to add to what Negar indicated there, but I really recommend that they get in touch with the Law Society in their province. Law societies usually have a complaints process if they have a complaint against a lawyer that they could follow if they have an issue with their counsel. If they have an issue with their counsel before it even goes to the IRB or before it even goes to a hearing and before they get a decision, it probably is a very good idea to contact legal aid in the province if the person is covered through legal aid, but also the Law Society, and try to deal with it even before you get to the hearing because you know, there might be a possibility to change the lawyer as well. So that's what I would recommend. In BC, it would be the Law Society in BC and legal aid in BC that they could contact if they have an issue. If it's after the hearing, after they get a decision, I still recommend contacting the Law Society, but also legal aid as well, since they should be aware if there's a specific issue with a lawyer that's been funded directly through them. So they could you know, follow those two different complaints processes. I will note that, you know, at federal court, sometimes these issues are raised in arguments at the RAD as well. You know, if you're raising an issue about competence of counsel in one of your appeals, it really does have to be well documented. There does have to be complaints in process, and it's a difficult argument to make. So I highly recommend, if there is an issue with them, that you try to address it early in the process, and you know, until not when you have a decision or wait until the end of the process, but also that if you do have an issue that you would like to raise after you've received a decision, that you follow those complaints processes, because that is really what is required when you're raising it on appeal as well. As one of the requirements, but it's not an easy argument to make, and really you should be doing it in coordination with any new counsel that you have who could give you legal advice on whether it's a proper argument to raise or not on appeal.
And I guess as a follow-up to that, the person had also asked about kind of a similar question towards IRCC. If they have a complaint about IRCC, what is their course of action, or is there one? Or
so for IRCC, there's no real separate body. So you could contact, IRCC has a separate line that you could contact to make a complaint. You could also contact the ombudsperson in your province as well, if you'd like, or the ombudsperson federally if you want to make a complaint. But generally, I usually recommend that you contact IRCC directly. I know it usually isn't very intuitive to say I'm making a complaint about IRCC to IRCC, but usually that would be the best course of action if you have an issue with IRCC, is to first contact them and then see if there's other avenues that you could pursue, perhaps through ombudsperson's offices in your province or federally.
we have another question. The person says they heard that IRB has a backlog currently of 90,000 cases. The largest in
nationally.
nationally, the largest in history. If this is true, what is the plan to tackle this moving forward?
Well, it is true, unfortunately. And part of the plan is exactly what we discussed, to basically to allocate our resources as proportionately as possible to the cases. So in other words, to not waste any time, including for cases that do not need to be decided with a hearing. We have really the FRP category when we expanded the number of members who take care of them. It was basically with a study of the current geopolitical situations in the world to see what are some of the categories that we may have missed in the past, and we compelled people unnecessarily to a hearing. So basically, this is one. The other was to not waste our time by not by the physical. There are lots of physical limitations of COVID. The very fact that we can only have 30% capacity, and that includes staff, it basically does not allow us to have full hearing rooms at all times. And that's why we basically expanded our capacity with remote. Actually, we expect that we can still finalize over 30 to 35 cases by the end of the year, despite the fact that we had so many months of nothing, no production, basically. So I think, but having said that, if you have brilliant ideas that we have missed, we'll be happy to take into considerations. But we've really, we are trying to keep all members at their full capacity at all times through whatever means. That if they can be in the office to do a hearing, do it there. If you have to be at home, do it there. If not, do FRPs, but make sure that basically you process files and you do it efficiently and fairly.
Great, thank you. And this is about the online hearings. If a claimant doesn't have access to reliable technological devices, are they to rely on a settlement agency, or does IRB provide the device, or how does that work?
It's a very good question, because we fully appreciate that a system that would depend on the claimant's own resources has its own limitations. So basically right now, it started as a very small pilot project, so it was not meant to capture everyone. And now that we are expanding it, we are looking at solutions, including, we are calling it access to justice rooms within our offices. We are equipping some of the rooms, and eventually all of our rooms, these hearing rooms, to the equipment that will support MS Teams hearings, where, for example, only the claimant can attend. And then the other parties are attending remotely. Those things, they need to be fine-tuned, because they need to be set up, like accessing a computer, a government computer by a non-government person has some legal ramifications. So we are basically, they're under very serious studies, and we are implementing them, but bear with us. And one option is also to engage the settlement agencies to provide, and that is the next stage, because it's definitely something that we have thought of, and it's one of the options that we are seriously pursuing.
Great. And so that concludes our questions. So we're a little bit early. I just wanted to ask kind of a general question to Azmudeh. So as UNHCR Canada, why would someone get in contact with you? Like, what is UNHCR Canada's role in supporting claimants or asylum seekers or settlement agencies, or, you know, in the process?
So we're a little different in Canada than we are internationally. As you could kind of tell from my presentation, internationally we do a lot more direct services to refugee claimants, refugees, internally displaced people, stateless persons. But in Canada, we're a much smaller office. We have an office in Ottawa, we have an office in Montreal and one in Toronto, but we're probably maybe a total of 20 staff nationally, and we're mostly located on this side of the country, and quite a bit of our staff is fundraising staff. So a lot of our work here at the national office is really geared towards advocacy and policy-based work, and not so much direct services for refugees and refugee claimants. But we do get people who contact us with questions and ask where they could go for help. So for example, we get questions about, you know, I'm a refugee claimant in Canada, I can't find a lawyer, where can I go? Or I'm a refugee claimant in Canada, I need to bring my family over, what can I do? So we do answer those questions, and we do give referrals to organizations in their region. So we'd be happy to assist for that. Sometimes we do get as well questions about refugee claimants in Canada who need access to something from their UNHCR file overseas for the refugee claim process. So we do get questions from claimants saying, well, I need proof that I was registered with UNHCR for the IRB, or I need information from my file for my hearing. So we do respond to those requests. I do warn though, for UNHCR, we do have a very specific data protection policy that doesn't allow us to provide a full copy of the person's file to them. Because there's a lot of sensitivities overseas and issues with stories probably being reproduced for claims, and a lot of data protection issues. So generally our policy, which is available online, is to provide people with information that they give us. So if they give us a document that we use in their file, we could give them back a copy of that document. But if they're looking for the reasons of their decision for a UNHCR refugee status determination process, we don't give them those reasons. It's very different than in Canada, because we've seen in the past, many years ago, those being reproduced sometimes fraudulently. So we've put in place a long time ago a policy where we don't provide the reasons for the refugee decision, but we could look at their file and write a letter confirming that they were registered with UNHCR, that they were determined to be a refugee, and things like that. So we do provide assistance in that sense. We do get people from overseas also contacting our office here in Canada, asking how they could come here through a resettlement program. We do provide general information about that as well, and direct them to proper referrals. Otherwise, if it's to intervene in a case, it's very rare that we would intervene specifically in one person's case. And it's really usually at the end of the process is when they've exhausted all their means, and we do a whole evaluation to see if it really warrants us intervening. And this is usually because there's so many processes in Canada, such as appeals, access to lawyers, and things like that, that it's pretty well established, the system here, so it doesn't usually require UNHCR intervention if they could access these other services. So usually that's what people would come to us for. We have also increased our information sharing online about access to the asylum system, especially during COVID. So we have a page on our online called Key Information for during COVID-19 for asylum seekers, and that usually provides information about what's happening at the border, can you come in and claim, what are the exceptions. So we do provide public information like that as well. So it's a bit more limited what people could come to us for, but generally if you have a question about whether they could come to UNHCR, I always say email us and we'll let you know if we could respond or not, or assist.
Okay, great. And I have one last question, and I know I promised you both I wouldn't ask any very case-specific questions, but I'm gonna try, and if you can't comment, that's okay. So the person says they have a client who's waiting for their hearing, and they're a new claimant, and then they heard about the pathway to PR for frontline workers, the healthcare workers. And so they spoke to their legal aid lawyer about this, and his lawyer said that they can apply, but that they would need like a large sum of money up front, like $5,000 to apply. Does that sound to you like it's correct, or?
Yeah, unless it's like, I can't give specific legal advice, but I would double check, because they haven't come out with the application materials or deadlines to apply or what's needed or any application fees as well. So unless that fee is for the lawyer themselves, I would ask the details of why that fee is required, because I don't know how much the application would cost. They should also, I'll send you a link to the news release, which states the criteria for people who want to apply under this category.
Okay,
and
great.
it's pretty like limited. So they have to have made an asylum claim before March 13th, 2020. They have to have been issued a work permit after they made their asylum claim. They have to have worked in the health sector in a health institution. So they have to have worked in a hospital, a long-term care home. They have to have worked in a designated occupation for no less than 120 hours. So there's a couple of criteria there that is very specific. So they might want to check that themselves too to see if they even qualify. And then for the fee for the application, that's not indicated yet. So, you know, it might be a good idea for them to question exactly what that fee is and what it's for. It might be lawyer fees. I'm not too sure. Like they would have to ask.
Okay. Okay, thank you. And I'll just turn it to both of you for any final comments. That kind of concludes our webinar for today, as there's no more questions right now.
I would like to thank you and your participants for inviting me and for attending and for listening. We face tremendous challenges, and we are doing our best to respond, and we completely understand that whatever we do and our responses, they don't come close to completely relieving the anxiety of the claimants. And we completely understand that they face sometimes very difficult situations. They're waiting to be reunified with their families. They depend on having a timely hearing and a timely decision, and sometimes, unfortunately, with 90,000 cases in our backlog, it's not very easy, but it's not because we are not fully mindful of their ordeal, and we really appreciate the services that you all provide to them to also make this a bit more bearable. So thank you very much.
And I just want to say thank you so much to Bahar for organizing and Negar for participating. It's great to see both of you. And to everyone for signing in, and the questions were great. If you would like to get in touch with myself or UNHCR, I could send my, Bahar could share my email address, but we also have a general email address as well, which I could share. So please feel free to get in touch with me if you have any questions. And thank you to everyone who participated, and especially I would like to recognize that IRB has been doing a ton of work during this pandemic. And they've been doing a lot of consultations. So I'd really like to commend them for all their work and their flexibility to respond to the situation. It's not an easy thing to do, especially in Canada, where we have very set processes and a really legal system that requires a lot of bureaucracy. So they've been doing some great work. So if anybody has any questions about the IRB process, like they've been really open to answering questions. So thank you, Negar, for really being available to do this today.
Thank you for having me.
Thank you both. Thank you both for giving us your time today. So it's I want to say a privilege to have, you know, this time with you and be able to ask you these questions directly. It's not often that we get access to UNHCR Canada and IRB, and you answered every question in so much detail. So thank you so much. And thank you for everyone for attending and staying with us for almost 2 hours. That always tells me that the topic was needed and the information presented was valuable when people stick around for the whole 2 hours. So thank you so much. And thank you to all the frontline workers that are supporting all the refugee claimants, asylum seekers. Like everyone said, Negar and Azmudeh said, it's a lot of work, and you know, and so thank you for your dedication. And if you have any questions or anything specific that came out of this presentation that you would like more information on, just email me and I will send out the deck, and I will also send out the Azmudeh's email address, since she's let us do that, so that if you do want to get in contact with her directly with any specific questions, you can. And yeah, and I'll be sending out an evaluation form for this presentation along with the deck and the video and everything. And also in there, you can let me know if there's any future topics that would be really important for your work, and I can make sure to kind of organize speakers for that as well. Yeah, thank you everyone. Thanks for attending, and I'll sign off now. Thanks.
Bye.
Bye everyone.
Okay, bye.